Hey everybody, I'm Mike Whalen for Law Insider. This is the Contract Teardown show, which is what it sounds like. We take contracts that are out in the world on the Law Insider archives, and we tear them apart with really smart people. Today I'm here with my friend Matt Johnston. Matt, how are you today?
I'm doing well. How are you?
Pretty good. It's early and the kids are up doing school, so it's probably a total disaster upstairs. The document we are going to talk about, guys, is this. This is an employment agreement from Sirius XM Radio. We're going to tear that apart a bit. Matt, tell me a bit about what is this document? When would you see it?
Sure. I'm working on a case that involves an employee non-compete, and I was looking around for interesting ways of structuring a non-compete and dealing with that. And I had read in the news that SiriusXM had hired themselves a chief financial officer, and I went to look for that contract, and surprisingly, it was already up on Law Insider, which was very nice. And so I started working through that, and um, you know, the contracts that like this you're going to see a lot when you're hiring people, when you're dealing with particularly executives or senior executives. So that's sort of why I went to find this and look through that.
Perfect. So we're going to talk about some good, some bad. We'll focus, really hone in on that non-compete clause mostly. But the first thing I want to do, Matt, real quick, is I gave you this document and you highlighted word after word. I'm scrolling through a bit. There's a bunch of quoted words in here. What are these things? Why did this catch your attention?
So these are defined terms, and some of them are more complex than others. But when I started scrolling through this, there are 37 defined terms in a 16-page contract. It just seems very excessive. It's also very distracting, and you lose a lot of the purpose of the content. So, as a general rule for me, if I'm going to have more than 10 defined terms in a contract, I'll have a separate definition section. And I'll put that either nowadays I've been putting it as a separate exhibit and telling people pull that out and have it handy while you're reviewing. Um, when you have all these defined terms sort of jammed in at random times, it really detracts from the readability, but more importantly, the understandability of the contract. You get lost in it.
Well, but I'm thinking about, like, I'm looking at some of these terms, and we're calling them defined terms, but they're not actually defined. We're trying to make these words look sort of important.
Yep.
If is their argument, is the reason for doing this, we're going to use context clues to have a defined term, and we're going to trust a court later to pull the context clues out of that sentence or whatever. It sounds like what you're saying is better practice is if you care enough about a thing to make it a defined term, to capitalize it and put quotes around it and underline it because you think it's cool, then just put it somewhere where a court doesn't have to go do an SAT test to find out what it means later.
Right. And particularly like I'm looking at one, let's see, where's a good one here? A defined term in Section 6, it says separation from service. Well, first of all, why are we defining that? What does it mean? And you have some complexity in there that doesn't really add to the contract or add to the understandability. So you're just cramming it in there to make it kind of, ooh, look at how smart we are as lawyers. And it doesn't really help.
We found
Now,
the underline button.
yeah. So it doesn't add to the understandability of the contract, despite the fact that the executive here and Sirius obviously have some very expensive lawyers and very smart people working on this. It doesn't really look all that impressive, to be honest.
Perfect.
So.
One specific section that you wanted to hone in on for positive reasons. Yes, guys, occasionally we do say that people did things right on these contracts, is the arbitration clause. Let me read it real quick and you tell me what you think about this. It shows, except as provided below, the executive and the company agree that this arbitration procedure will be the exclusive means of redress for any disputes relating to or arising from the executive's employment with the company and or holdings or his termination, including but not limited to disputes over rights provided by federal, state, or local statutes regulations, ordinances, and common law, including all laws that prohibit discrimination based on any protected classification. As a writer, I want a couple more periods in there, but what's bugging you and what are you liking about this section?
So I agree with you. They need to find the period button. We're clear that they know where the underline short keys are. We need to use a period. But what I like about this is it classifies the claims that are going to be included in the arbitration clause. Oftentimes it just says any dispute, and it doesn't matter what the subject matter is, except that there is an exception, which if we scroll down a little bit, in section, it's subsection B here, it says that if there's an action seeking injunctive relief, it's exempted from section 20A, which there's a small little numbering thing. There's actually two section 20As, but what I like about it is we've defined what claims and included specific things like, discrimination claims or things like that, his termination or his employment. But then if there's an injunctive relief related to confidentiality, non-compete, things of that nature, that's separate. And so a lot of times when you're dealing with an arbitration clause, there's no exception for injunctions. An arbitrator can't issue an injunction and have it mean anything.
Right.
But you need a court to do that, and oftentimes injunction or injunctive relief is not even considered in the arbitration clause. So that's why I really like it. I thought it was well done to address that particular issue.
Perfect. We say nice things sometimes, people. So I'm going to go over and share the screen because we're going to really dig in on this non-compete. And as you can see, Matt likes bright colors. This is probably my fault. This is from Word and then translated over to my Mac. But we've got some big sections here, and rather than me read them because that will take forever, I'm going to turn some time over to you, and we'll chat about this. But that green section on the non-compete, maybe tell me overall why you like this thing, and then we'll go to these individual sections that you've highlighted.
So non-competes, and people need to sort of understand that a non-compete is kind of a disfavored kind of contract or covenant, largely because you are going to be limiting somebody's ability to go out and make a living. Now, I don't think the executive, if you read through this contract, this executive is not going to be hurting if he's subject to a non-compete.
I think he got like a $700,000 bonus if he left or whatever. Yeah. Nice work if you can get it. Well done, buddy.
Yeah, he gets a guaranteed $700,000 bonus. Well, that's nice. Thank you.
Happens to me all the time. I mean, come on. Yeah.
So when you set up a non-compete, you want it to be A, very clear, and you want it to be B, well structured so that you don't run the risk of a court or an arbitrator saying, yeah, this doesn't apply because you're either overly broad or you haven't considered something. So you want to do things from a very structured standpoint. So the first green part that's on there, and again, sorry for my technical choice of words here. The first green part actually, the first part of it says the executive shall not directly or indirectly enter into the employment of, render services to, or acquire any interest whatsoever in an entity engaged in a competitive activity. So if you look right about the fourth line of this, you start to get a definition of what competitive activity is. And again, this is one of those things that would have been nice to pull out and put into a separate definition section. Because then you can simply say, during the executive's employment with and during the restricted period, the executive shall not do the competitive thing. And you're clear, and you're not shoving another 50 words into a sentence, which, both of us as writers find offensive on many levels. But the interesting thing about this is if you scroll down a little bit further, there's another definition. And you'll see the green section where it defines the term radio, which is used up in the first section, which says transmission or streaming of radio programming. So we've actually split apart a definition or crammed two definitions in there. And it seemed like an afterthought. And that's dangerous, because then you're like, what does that really mean? And how does all that work together?
So at minimum, if you're going to ask a judge to use context clues to define a word, at least put that definition in one spot?
Yes.
Yeah.
And I'm highlighting because there's also a definition of a restricted period that's jammed in here. And there's also another defined term called milestone date. So you're confusing things and what matters mean. And you don't want to do that. If you want to have an effective non-compete, you want to be absolutely crystal clear. And oftentimes, the fewer the words, the better. So that's generally where that structure comes from. So the idea of saying you shall not enter into the employment of, so an employee, render services to a contractor or consultant, or acquire interest, own, but there's an exception to that. And that gets us down to that first purple thing that says, nothing in this agreement shall prevent the purchase or ownership of the executive by way of investment of less than 5% of shares of equity interest in any corporation or other entity. So it doesn't actually say acquire any interest whatsoever. We have an exception to that. So you have to I believe that you should set the exceptions apart. Okay, so that, and maybe in a separate section, and certainly by themselves, so that there's a clear understanding of what is accepted from the general rule.
And this red section, which looks very angry. It's a very angry red. It begins with without limiting the generality of the foregoing, which is I thought, a nice way to put that, to recognize that there was generality. Tell me about this red section. What's bugging you here?
So what bugs me here is this isn't actually, it's kind of non-compete-ish, but it's not. This is a non-solicitation. That basically says the executive cannot solicit SiriusXM customers for another entity. And then there's a section that says you can't solicit or hire employees of SiriusXM. So oftentimes when you're looking at covenants not to compete, there's the non-compete in terms of employment, but there's also a non-solicitation of customers and employees. And interestingly enough, or at least in my experience, courts are far more willing to enforce a non-solicitation provision, because you're saying to the executive or the employee, you can compete how you want, you just can't compete with this universe of customers. And it's an easily defined universe of customers. Granted, Sirius has a very large customer base, but you're saying that it's okay to compete, just not in this universe and not with these people.
Right. At least in that case, you could make a list of who those companies are.
Absolutely.
Where if it's too general. So thinking about principles here as we close out, what is it about the non-compete? Are you? My sense is that with these, judges don't like non-competes in general. Like they want to kill them. They want to find reasons to get rid of them. And it sounds like what you're saying is, because this is not using a structure that makes what's in and what's out very clear, it sounds like judges would be inclined to say, this isn't clear, we're going to get rid of it.
Right. I think that's generally the case, at least in the jurisprudence that I have seen, is they're kind of looking for an excuse. Now, when you're dealing with SiriusXM and this guy who, if he gets terminated improperly, gets a $13 million severance payment, I don't think the court is going to have any particular problems enforcing this.
Yeah.
But if you're going to be doing it for other employees, and you are not going to be making a $13 million severance payment, you're probably going to have to find a way to be very, very clear. And it's far better to be simple, use a combination of definitions and a general rule followed by exceptions, rather than trying to jumble all of this into one thing, and then put your non-solicitation and your non-solicitation of customers and employees separate, and make sure you have a really good severability clause. So that, people can say, okay, all right, this isn't good, but this is, and this is.
Perfect. Well, because it's 2020, I've got a cat at my feet about to jump on my lap, so we're going to wrap up. Matt, if people want to get in touch with you to talk more about non-competes, you've been doing a lot of research on this lately. What's the best way for them to get in touch with you?
The easiest way is through my website, which is mattthelawyer.com, M-A-T-T, thelawyer.com, nice and easy. Or on Twitter, I'm at Johnston BLG.
Perfect. And guys, we're going to share this contract in the post at lawinsider.com/resources. We'll give you the link for where you can go get this contract on Law Insider so you can take a look at it. If you're not a member of Law Insider yet, go sign up. There's a free version. You can try it for a while. And if you like it and you want to use it a lot more, you can get the premium version. Just go to lawinsider.com/resources for this post, for future posts. We'll see you guys in the future on the Contract Teardown show. Thank you, Matt.
Thank you.